Hey everyone, so how are you all? As you all know, a bit ago, I have already uploaded this video in Hindi language, but many of you are demanding the English version of the same video. So here I am, but in case if you want the Hindi explanation of this video, you can watch that video by clicking the link in the I button. So for a proper understanding, you should watch this video till the end. So first we need to discuss the name of the case. So the case name is TRL Krosaki Refractories Limited versus SMS Asia Private Limited 2022. Actually the case we are discussing today is very important because this case contains some of the most important provisions of Negotiable Instrument Act of 1881 regarding the dishonour of a cheque, and also it shows some of the important observations and guidelines laid down by the Honorable Supreme Court along with some important questions which occurred in this case. Firstly, we need to discuss the parties who are involved in this case. As you can see, TRL Krosaki Refractories Limited is the appellant and the respondent is SMS Asia Private Limited. Another important thing that you all should remember in this case is that both the parties are companies, not individuals. Before proceeding further in the video, we need to discuss the basic meaning of cheque dishonour with the help of an example. So it will become much more easier for you to understand this case. So as you can see, there are two persons in this example, that is X and Y. X has to pay rupees 1000 to Y as he borrowed those 1000 rupees from Y a month ago. But when the time of the payment comes, X gave cheque of 1000 rupees to Y for the payment of his debt. So when Y goes to the bank for withdrawing the cash through that cheque, the bank authorities told Y that the payment cannot be made because the person who made that cheque have only 300 rupees in his account, but the amount mentioned in the cheque is of 1000 rupees. So due to insufficient funds present in the drawer's account, the cheque is dishonoured. Now in that situation, Y can file a case against X for the dishonour of a cheque by considering the section 138 of Negotiable Instrument Act 1881. So this example simply tells you about the situations or circumstances which comes under the ambit of cheque bounce और dishonour of a cheque. चलिए आपके साथ एक चीज शेयर करता हूँ. लॉ समझना इतना भी मुश्किल नहीं है अगर साथ मिलकर समझेंगे तो, और ये चीज तभी पॉसिबल हो पाएगी जब आप इस नोटिफिकेशन बेल को दबाएंगे और मेरी वीडियोस सबसे पहले पाएंगे. तो कर दीजिए क्लिक. So section 138 of Negotiable Instrument Act 1881 plays a vital role in this case as it deals with the offence of dishonour of a cheque. So let's discuss what section 138 talks about. So it simply says where any cheque is drawn, which means made by a person on his account or the account maintained by him for the payment of a particular amount of money to another person from that account for the discharge of a particular debt or a liability, which can be discharged wholly or partly. But the cheque which is made by a person to discharge a particular debt or a liability, that cheque is returned by the bank. As a result, particular debt or a liability which a drawer of the cheque wants to discharge remains unpaid. The bank can return that cheque because of some reasons. So let's discuss those reasons. Those reasons are when the amount of money standing to the credit of that account is insufficient to honor the cheque, which simply means the person who draws the cheque or made the cheque has insufficient balance in his account to discharge a particular debt or a liability. Another reason responsible for the same is that if the amount of money exceeds the amount arranged to be paid from that account, in that situation the cheque can be returned by the bank and the person who draws that cheque, and if that cheque fulfills the reason that I mentioned before by which a particular bank can return the cheque, in that situation the person who made that cheque shall be deemed to have committed an offence and shall be punished with imprisonment for a term which may be extended to 2 years or with fine, and the fine can be extended to twice the amount of the cheque or with both imprisonment and fine as well. So as I already told you in the previous slides that this case is important because a particular question is occurred in this case. As you can see, that question is who can represent the company in a cheque bounce case. So in the remaining video, Honorable Supreme Court answered this particular question along with also laid down some important observations and guidelines related to that question. So before discussing the answer of that question, firstly we need to discuss some of the important facts regarding this case. As you all can see, SMS Asia Private Limited, who is respondent in this case, issued several checks in favor of the appellant, that is TRL Krosaki Refractories Limited, for the payment of their debt. But the checks which were issued by the respondent was dishonored because of the insufficient balance in the respondent's bank account. When all the checks was dishonored due to insufficient balance, then the general manager on the behalf of their appellant, that is TRL Krosaki Refractories Limited, filed a case for the dishonor of the check against the respondent. So after filing the case against the respondent said that the general manager of TRL Krosaki Refractories Limited is the incompetent person for filing the complaint because complaint does not specify that the general manager have or does not have the knowledge regarding the transactions. So finally, Honorable Supreme Court laid down some important guidelines and observations regarding the issue occurred between appellant and respondent, and also ensure the solution for the questions that I've told you before. Honorable Supreme Court mentioned that while drafting the complaint, there are certain things that should be mentioned in that complaint, which are: the person who files the complaint should be an authorized person, and after only that a person can represent a company in a check bounce case. Supreme Court also stated that a person should have the knowledge about the transaction, and that knowledge can be indicated by the complaint or a statement either orally or by an affidavit. As we all know that the respondent claims that the general manager of TRL Krosaki Refractories Limited is not the competent person for filing the complaint because complaint does not specify that the general manager have or does not have the knowledge regarding the transactions. So Honorable Supreme Court also resolved the issue of the whether the general manager is a competent person or an incompetent person for representing his company in a check bounce case. Honorable Supreme Court said that the documents which were introduced before the Apex Court clarifies that the general manager is an authorized person and have the knowledge about the transaction according to which he is eligible for representing the company in a check bounce case. As you can see, the question which was discussed before, the question which is who can represent the company in a check bounce case. So the person who is an authorized person and also having the knowledge about the transaction, which can be indicated by the complaint or a statement either orally or by an affidavit, that person is considered as a competent person which can represent the company in a check bounce case. So by the help of the guidelines and observation laid down by the Honorable Supreme Court, we finally knew the answer of the question occurred in this case. So that is pretty much it for the video. Hope you will get all the information that you have seeked for. But in case if you want the Hindi explanation of this video, you can watch that video by clicking the link in the I button. Have a great day.